most recent case law on this is Hardin v. State. And in that case, it overturned even Lemming. And they went as far to say is that failure to maintain a single lane is not probable cause for a stop.
Well, I get it, right? You have to dictate more than just saying failure to maintain.
Judgment sprung, in and out, the verdict swung. Oouchie car watch, we've just begun. Oouchie car watch, we're on the scene. Truths unraveling, what does it mean?
Mr. Simon, how are you? Great to see you. Ready? Who do you have?
I am here on Albert Anderson, Your Honor.
Page 1, Anderson, come on up.
Mr. Simon, great to see you.
Good to see you, man. You doing good?
Yeah, you know, working. Good morning, Mr. Anderson. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 8th, 2024, the officer conducted a traffic stop on the defendant's motor vehicle after observing it failed to maintain a single lane while traveling west on Jester Boulevard. The officer observed the defendant constantly veering out of the lane and going into the second lane. The officer observed the defendant to be the driver and sole occupant of the vehicle, and while speaking to the defendant, the officer observed a strong odor of an alcoholic beverage and bloodshot eyes. The defendant was struggling while exiting the car and was swaying back and forth while speaking to the officer. Standard field sobriety tests were performed, HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read, but the defendant refused and a blood search warrant was drawn and executed.
Your Honor, may I make argument, Judge?
Sure.
Thank you, Judge. The sole reason for the stop in this case was failure to maintain a single lane. Most recent case law on this is Hardin v. State. And in that case, it overturned even Lemming. And they went as far to say is that failure to maintain a single lane is not probable cause for a stop.
Well, I get it, right? You have to dictate more than just saying failure to maintain.
Yeah,
You have to have provide
a danger to another vehicle. There's other vehicles around. And this is on TC Jester Boulevard, a very sparse road at night. And this
So what were the indicative facts?
I'm opening the office.
Yes, Your Honor, we're looking at the offense report.
I mean, obviously, we don't have any body cam, dash cam, so I'm not,
Well, right, but this is just a mere probable cause. I need enough of a statement from the officer in the DIMS saying how he justified pulling the car over in light of failure to maintain a single lane. The weaving statute. I mean, do you need a bit of time? If you want to reconvene in like maybe 30
Yes,
minutes,
Judge.
it's fine.
My offense report's not running for some reason, so.
If we may have a little bit more time.
Mr. Simon, do you mind? Do you have somewhere else to go?
I have Fort Bend to go to. Can I go to Fort
Well,
Bend?
That's going to take hours. If you want to, yes, because you can always zoom in. I have Zoom for you.
I'll wait.
So perhaps maybe, 15 minutes, give them time to look at the OR.
No problem.
Just take a seat for me, Mr. Anderson. We'll come back.
What?
For now, we'll have you sign a reset.
Oh, no, okay.
Okay. So, Mr. Saman,
Yes, Your Honor.
the cases that you provide me, I think the distinguishing thing is that all of them have one instance
Well,
of
not the Hernandez, which is kind of the genesis of all these, and that one.
Hernandez is one time.
No, Hernandez is 4 to 5 times, I think, is what they say.
I'll point out that Hernandez was rejected by the court in Lemming as well.
Yeah, but then Lemming was rejected by.
Lemming was not
Hardin.
rejected by Hardin. They
said
disagreed
you-
with the state's application of it in Hardin, but it was not overruled or rejected.
Well, I think Hardin.
Hold on.
Sorry, Lemming was rejected on point because there were other factors that Lemming brought up, such as the danger to other vehicles.
It's a totality argument is what the court is stating in Hardin. It says thus, even under the circumstances in which a motorist crosses from one lane to another without necessarily raising a safety concern, that behavior can still be considered along with other facts to provide reasonable suspicion to stop for
Sure.
suspicion of driving while
Of
intoxicated.
course. I mean, you look at the entirety of everything to see, hey, is there enough to justify the stop, right?
I agree.
On the failure, of course, that one is just time that's insufficient, right? And I think there's enough cases to say that out there. But when you have multiple times,
Mhm.
I think at that point, that may, because they could be a potentially danger to themselves as well. Here, the only problem, my problem here is he says, what's the one word he uses?
Constantly.
Constantly.
And I understand,
Constantly is conclusory.
I understand he
is.
could have been more specific, Judge, but I mean, this is a probable cause matter. And the fact that he even put constantly rather than failure to maintain a single lane, because I mean, I've seen it where it says traffic stop initiated for failure to maintain a single lane, you know, so he did take
I
the
mean,
time to
that's
put
so
constant.
conclusory, right?
Right.
And I mean, constantly definitely indicates more than one, right? But I don't know. What does constantly mean?
It doesn't, and like you said, it is conclusory, and unfortunately, I think that we have to go by what is stated in the probable cause statement, and in
Sure.
this case, we don't know, and if there's a question, I think it has to go on the side of the defendant.
Judge, I think we have enough for probable cause. He said constantly, I mean, he still indicated.
Read it
it's
word
more
for
than-
word again, one more time, please.
Officers conducted traffic stop on defendant's motor vehicle after observing it failed to maintain a single lane while traveling westbound on TC Jester. Officer observed defendant constantly veering out of lane 1 and going into lane 2.
He also states, I'll go further because I actually went into the probable cause that was written up for the blood warrant, and in the probable cause for the blood warrant, it says almost strikes the curb.
I feel like that makes it worse, actually.
Well, I don't think so, 'cause I don't think so, because I think almost striking the curb is also
Because
like,
he's now swerving between 1 and 2 lanes and he's going back over and almost hitting the curb.
Sorry, it is a totality, so that would be an additional
That's
fact. the
veering
officer
between
could-
lanes.
I mean, I think it's all very, very,
Judge, I'm happy to re-examine this case once we get more evidence in. I asked that you find PC today, but once we get Dash, if we can look at it, I'm happy to discuss with counsel the circumstances of the stop once we get videos. I am, but I think this is sufficient for probable cause.
I would argue that it's insufficient for probable cause, and if they do get the videos and they do feel strongly enough about the case, if they have a case that will make it past, cut the mustard, then they can refile it.
And Your Honor, respectfully, in Lemming as well, one of the facts that the officer indicated was the vehicle nearly striking a curb in addition to weaving within his own lane. So in Lemming, that was found to be enough for probable cause, even reasonable suspicion to perform the traffic stop.
It's
Well, I
also,
think
I
there was
think-
other vehicles around in Lemming, that was the problem.
Well, in Lemming, respectfully, he didn't even enter the second lane. He was merely incidentally weaving, touching the center stripe. In this case, he entered into a second lane. So in addition.
I mean, if that's the case, then if that's the case in Lemming, then there is probable cause. I mean,
Yes, Judge, and
it
that's.
says that there's,
But there's
It
other
said-
vehicles around. in
It says
Lemming.
that he touched the center stripe of the lane, the rear tire of the vehicle, and nearly struck a curb. That was the facts that the officer had at the time when he performed the traffic stop.
and that's how it was also distinguished from Hardin, because in Hardin, it was somewhat similar in that he was kind of towing that center lane, and they held that there wasn't reasonable suspicion for a stop, which is understandable. But you also have to take into account other factors, such as this is at 2:00 in the morning. I don't know what date this was. This is on a Saturday, late Saturday night, 2:00 in the morning when bars close. There's other factors here at play, Judge. It's not at, 1:00 in the afternoon on a Tuesday.
I will state that in Lemming, I believe, correct me if I'm mistaken, but there were other cars around, and that was a factor that they brought up near the vehicle.
It's fun.
It is fun, it is fun. It's Christmas.
I
It's
know.
Christmas.
Usually people just roll over. Nobody ever does this.
I know. My neighbors, it's my neighbor's children, so I'm trying to help. I'm trying to help them over here, and y'all are running.
Crystal Smith,
All right, I think coupled with that one, I think that, Mr. Simon, I'm sorry, I think it is, I mean, it basically, this case here tracks that case.
I think that the distinguishing factor is no vehicles around. And I think that's what they kind of hung on to in those other vehicles around.
They don't even mention that here.
What?
They haven't even mentioned it here. It says here, look, it says, the combination of the tip and his own corroborating suggestions. Twice Gillo observed the Jeep nearly strike the curb, drift back and forth, and this one is within its lane, if to somewhat a lesser extent for some time. It was traveling well below the speed limit when he first observed it.
May I read a portion of the sworn statement by the officer for the search warrant?
Sure.
So the officer stated that he observed a motor vehicle driving in lane 1 and then swerve into lane 2, almost striking the curb. He continued to follow the vehicle and observed him constantly jerking while in lane 1. As the motor vehicle continued to drive, a turning lane opened and the motor vehicle veered into the turning lane and then back into lane 2. And that's when the officer initiated the traffic stop. So it seems like it's multiple
Two different
lanes.
times. So it's only 2 different times as opposed to the constantly that he wrote in his report.
Nearly striking the curb. I mean, I think it's enough for now.
Okay.
Now,
I'm not gonna argue with you.
No, but
Any more than I already have.
look, I'm never going to begrudge a lawyer from doing it. That's your job.
Yes,
And I
yes,
want you to do it, right?
Yes.
But remember, it's only probable cause.
And Your
It's
Honor.
not a beyond a reasonable doubt. If this is all that's there, but right, I don't know.
Okay.
So, all right, come on up. This is Anderson, right?
Yes, Your Honor. No criminal history.
Okay. So I want you to understand, coming up over here. I want you to understand something, Mr. Anderson, that probable cause is a pretty low standard, right? It's just to see if there's enough evidence to go forward. It by no means that you're guilty of this offense, and that's a high standard. It's a beyond a reasonable doubt. And I can let your lawyer explain that to you, but this is just a mere hearing to see whether there's enough evidence to go forward. I think that there is. And the only restriction I'm going to place on you now is don't consume alcohol, don't use illegal drugs. As long as you can comply with these conditions, you and I will be fine. You've got a great lawyer, as junkyard dog as he can be, right? Listen to him, he'll take care of you. I'll waive your appearance. You don't have to waste your time coming to court, but just stay in touch with Mr. Simon. He'll tell you when you got to come back. Have you guys run his license? See if he has a license?
He does have a license and it is valid, Your Honor, and we've requested ALR on that, so we're all good.
Okay. So as long as you have license and you maintain liability insurance, because you have to have car insurance. If you don't have car insurance, don't drive. Do you understand?
Yes, sir.
All right. Now I'll let you guys go. So I'll have you sign a receipt with Victoria. We'll have you get with Fleischer for your bond conditions, and then you guys free to go.
Thank you, Judge. Have a Merry Christmas. I won't see you before then.
Judge, what was it again overdue? Chavez, come on up.
Okay. Did you have a?
Yeah, arrangements, Mr. Chavez.
Okay.
You're good.
Good morning, Owen.
Every other weekend, we go to, there's a small restaurant called Prima Pasta. They have a singer who wears a different blazer every time he comes in. How many
Just look like it.
How many blazers do you have? I guess.
Quite a bit. All right, good morning, Mr. Chavez. Mr. Chavez, you're charged with reckless driving. You're facing up to 30 days and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. The street takeover task force was investigating a takeover in a parking lot in Harris County, Texas, when the officers observed the defendant doing donuts in the vehicle, coming within 10 to 15 feet of other vehicles that made up the pit. The officer saw the defendant do approximately 3 to 4 donuts, and undercover officers maintained visual until uniform officers made a traffic stop. The officers observed the defendant operating the vehicle in the driver's seat.
Mr. Chavez, I'm going to find that there's probable cause to go forward with your case. Do you have a Texas driver's license?
Yes, sir.
Do you have liability insurance in your name?
Not in my name.
Then you're not allowed to drive. I'm going to have you sign an affidavit with me today promising me you're not going to drive. Let me make something else perfectly and abundantly clear to you that the Texas legislature has made it extremely easy for district attorneys across the state of Texas to seize and take cars from individuals who partake in this type of action. In fact, we had one here yesterday where a car was seized, a very, very expensive car on a second. Do you understand?
Yes, sir.
If I find that you endanger my public, then likewise, you will go to jail. I'm going to revoke your bond if you endanger my public. I'm going to do everything in my power to protect it. Do you understand?
Yes, sir.
Before you start driving, you must come back and get approval from us. Do you understand? Don't just start driving because I don't want to take your word that you have a car insurance. Owen can get with you, come back. He knows how to handle this. Do you understand?
Yes, sir. But the truck has insurance.
I don't you have a lawyer. I don't want you to say anything now.
Okay.
Just get with your lawyer. He can advise you how to go forward. But I'm telling you now, I'm ordering you not to drive. You don't have car insurance.
Yes, sir.
Do you understand, Mr. Chavez?
Yes, sir.
Okay, I'm gonna have you come up here, swear to us that you're not gonna drive. I'm gonna get you to Victoria. We will have you sign a reset. It is your responsibility to stay in touch with Owen. If Owen tells me that he can't get a hold of you because you're playing games, it's not gonna go well for you here. Do you understand?
Yes, sir.
All right, come on. Thanks, man. Hey, can you file? So we need him to also sign bond conditions. Owen, I also need him to sign bond conditions, no reckless driving, donuts, racing. So we'll have him take a seat in the jury box. Once he signs it, then
Yes, Judge.
please.
Page 12, Morales.
Come up, Mr. Mireles. I'm so happy that you're here. I'm really, really happy that you're here. Thank you for coming.
No problem, no problem.
Really, I think that it's a big feat that you're even here because in times past, so I'm really happy that you're here. Come back. Good things happen, Mr. Mireles, when you come back. We're not bad people, I swear.
Thank you.
So what's going on now?
He picked up this evading. They are waiting for discovery on it before they make an offer. They want to look at discovery before they make an offer.
Is discovery complete?
We're still waiting on body cam and dash, Your Honor.
Okay, I mean, it's only 50 days old. Where are you living? What are you doing with yourself these days? Shh.
I'm still staying like kind of in between shelter, and then I'm also on the street a little bit. But
No, how do we get you off the street?
hard. I went to my caught houses, and I went there, and it was very strange because with the paperwork and everything that I had to deal with, it was hard to explain. They told me I was going to one house, but I ended up going to another house, which was complete opposite of what they had said that I would be going to. The conditions were much worse than I had expected. And it just,
Shatoria, what can we do to help Mr. Mireles as far as housing? Do we have? He's gonna qualify for the TAP funding. There's no doubt. We've got a list of places. Do you have a phone?
Yeah, I run off Wi-Fi, but I do have one, so I'm gonna call.
Do you have a phone? Okay, so there's a list of places that you can go there that, so what specifically can we do, Shatoria? Like housing wise? Oh, well, no, but I mean, I know that you have stuff to do. I mean,
He can follow me back to the office and we have a social worker there.
wonderful. Do you mind doing that so we can find you a place to stay?
Yeah. If not today, I have to get her to the vet and it's offered for free. She has to get her shots.
Whoa. I don't want, if once you go, you're not coming back. You're here already. Just why don't you go talk to them?
If I miss her shots, but I'll go.
You could get the shots later.
Yeah,
Okay, whether you get it now, whether you get it in 4 hours, it's not gonna make a difference. You're already here.
I understand, yeah.
Really, we can try to find you a place to stay.
Okay.
Or would you prefer to stay on the street?
No, it's just, I don't know, I'm not so optimistic. I've tried several times and
It's a lot with the initiative that the city of Houston is doing, getting the people off the street, shelters are filling up.
I just kind of gave up hope with getting help.
Don't give up hope. Never give up hope. There's always something out there. We can always find you something. It's you gotta want it though.
Yeah,
Right.
I do really want to.
And stay with Lori. Let me get you over there today. I mean, I'm happy that you're here. No one's gonna do anything to your bond. Just keep coming back and good things will happen. The only other thing I'm gonna ask you to do is stay in touch with Lori.
Oh,
Okay, whether it's via email, whether it's phone, however it may be.
yeah.
You know, when you do that, good things will happen. Unfortunately, we can't do anything with your case today because they don't have the evidence. Can you get it as quick as possible, Alex,
Yes, Your Honor,
please?
we can reach out and get an escalation, Your Honor.
Please,
Yes, Your
you
Honor.
know, time is of the essence.
Yes, Judge.
So why don't we pick a court date now, so he knows when our next setting is? Okay. Please go with them, all right?
Okay, well, yeah.
Come on, good things happen when you come, you know that.
Really, thank you. All right, hey, it's great to see you, Mr. Menendez,
you.
really. I'm proud of you for coming.
Come on up.
Juan Manuel, come on up. Hey, keep it down. Juan Manuel Martinez.
Yes, sir.
So you're charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The complainant and the defendant are married. On December 5th, 2024, officers were dispatched to a residence in Harris County, Texas, in reference to a family disturbance. Officer met with the complainant, who stated the defendant arrived home intoxicated. The defendant was still in his car, and she went over to remove the keys from the ignition. The defendant walked up to the landed on her left knee, on herself with her left hand. The complainant stated she felt pain from being pushed and from hitting the ground.
Mr. Martinez, I'm going to find that there's probable cause to go forward with your case. I am now ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? I don't know what your immigration status is, but I'm going to give you a warning now. And this is the only warning that you're going to get. If you're not in this country with permission, you violate the laws and you go to jail and immigration finds you there, they will put a detainer on you and you will sit in jail until this case is over with. And then you will be shipped off to immigration, where you will sit for another 6 to 9 months waiting for immigration to do whatever they're going to do. If you do not want that to happen, do not violate the conditions I put on your bond now. If you violate these conditions, I will issue a warrant, put you in jail, and that's it. Do you understand?
Yes, sir.
Okay. Like I said, no alcohol, no illegal drugs. You will be randomly tested. If you fail to go test, likewise, a warrant will be issued for your arrest. A protective order was issued in this case on December 6th. I suggest that you get to know it. If you violate the protective order, the state can possibly will file a violation of protective order against you, and it's one of the worst cases that you can pick up in misdemeanor court. Do we know whether she wants to have contact with him, guys?
Your Honor, no, RIP was attempted, but she was unable to speak at the time that we called, so we'll call again when we can.
I don't know whether she wants to have contact with you. So until I know that, I'm ordering you not to have contact with this person. I don't care what your excuse is. Excuses mean absolutely nothing to me. What matter are choices. You can either make a wise choice or you can make the wrong choice. You know what the expectation is here, and if you make the wrong choice, there's only one place we have for you. Do you understand? No alcohol, no illegal drugs, no weapons. Don't have any contact with this person, and don't violate the protective order. Do you understand? All right, we're going to reset your case to give you time to hire a lawyer. So I'm going to first have you go to Victoria Center reset. I'll have you meet with Felicia for your bond conditions, and after that, you're free to go. You ready?
Yes, sir. How are you, Judge?
That's Friday.
I know. Judge, we're back on Tristan Smith. And Tristan is in court today.
Come up, Mr. Smith.
Your orders were for Tristan to report for drug testing, which he did. We received the results as a positive for THC usage. And he's here to speak with you.
Felicia,
Yes, Judge.
when did we first test Mr. Smith?
So for Mr. Smith, I see an order prior to when I was here on October 7th to have Mr. Smith go to a drug test that day. He never reported, so that's why the BVR was filed. And so then we had a test on the 9th, and those were now confirmed by the lab positive for THC. But I believe.
So that was October 9th.
No, October 7th, we ordered them to test, they did not.
Okay.
We caught that a little late by the BVR, and then we adjusted a little bit last week, I believe, or the beginning. of-
How is it that we ordered him to test in October and he's now in December testing? How on earth? It's unacceptable.
It was a court-ordered drug test, and I don't think you wanted them to come back after testing.
But if they don't test, then they're required to come back and we either make them test again or or there's other ramification, but we don't, how on earth can we go a month and a half and then nothing happens?
Yes, Judge, I understand, but we did, per your orders, we tested them again this week, and those did come back for THC.
Who was here working that day?
I can look into it, but it's really no way of knowing for sure because there was no assigned officer here at the time.
Someone had to have signed an order to go test.
I think so, right?
There's always a way. There's always a paper trail.
Yes, Judge. Sorry, this was from the court, since they never made the appointment, but it was one of our officers' noses.
What do we do with this, Mr. Brooker? How do we hold Mr. Smith accountable?
Judge, I know what I've done since Monday. Mr. Smith and I have talked very frequently this week. I admonished him thoroughly about the THC usage. He explained to me what happened with that, and he understands the seriousness of it. He understands what's at risk. It's correct what you said, that he doesn't have any support out there, financial or otherwise. I'm actually happy that he was able to make it here on time today, because I was concerned about that. So that was twice this week. He wants to be compliant. He wants to do what's best. He wants to dispose of the case.
I don't believe that.
I know, Judge.
I don't believe that. He's telling me that you want to be compliant. I don't think so. You repeatedly do whatever you want to do without regard to court orders, and it does not work like that. You repeatedly fail to appear here. You blow off the test, and now you're testing positive. What am I supposed to do? Just let you go?
I didn't repeat, I missed one day, and that was the day I was supposed to come, and I didn't have no way up here. I didn't even.
You can take the bus.
I'm in Humble. The bus did not come out of Humble. I'm literally sleeping at the park right now, like, okay, and I'm still, okay, listen.
And Judge, even with those challenges, Tristan has been in school. Even on the Zoom appearance from last week, I believe he was Zooming in from school that day, the day that he couldn't make it, and got down here on that Monday.
I don't know what to believe with him. I really don't. Unless you provide me proof with something, I'm not going to believe a word that comes out of your mouth. I don't believe, because the problem is that you tell me that you're going to, you tell me you're going to do things, and then when it's time to, you don't. So how am I supposed to handle this? What am I supposed to do?
Judge, he came in on Monday. You ordered him to take the test. He went right over.
I literally walked here. I didn't have nowhere. I walked here.
He went over.
That was a whole 4 hour. I walked here from school. I walked here all the way from Chattanooga.
I'm not asking much. I don't want you to use. Do you understand?
Judge, if I may add, I have communicated with his grandmother. I believe it was on December 5th that I called
Oh,
her.
you spoke with Grandma?
I did.
Have you let Mr. Brooker know first?
Yes, Judge, I recorded. I took details of the conversation and shared it promptly with Mr. Brooker.
How do we go forward?
So it appears as though, based on my conversation with Miss Karen, that the defendant has gone to the house, the residence since then with his friends. He refused to leave even upon her request. There is a MOAB in place, Judge, where he was supposed to have no contact with the residents, and per his bond conditions, I don't believe he was supposed to have contact with her either. And he has gone to the residence.
And now we have even more. I mean.
And she did file a police report, I believe, Judge. She told me she called the police and they filed a report, and she has an offense number.
Mr. Brooker. Do you guys want to talk about this and then?
We can, Judge. We can.
Does she want him to come back or no?
No, my understanding, and I also heard from one of the family members, I believe Tristan's sister, they don't want him to come back. And mentioned something about whatever was the underlying dispute about some property or whatever. I didn't respond to it at all. It just didn't seem like the right thing to do. But as Tristan has indicated, everything he said to me is that he's been living outside, doesn't have anywhere to go, which is my original concern with him. Took him downstairs to try to get him some kind of services. It's just not really a workable situation, but he's communicated with me. We've talked this week. This is his second time here. He took the test, Judge. He was forthright with me. He understands what can happen. I told him.
What do you want me to do?
Judge, just that he continue having no contact with any of the complainants. They are fearful of the defendant. They do want him to get help. I've also spoken to his mother, and she wants him to receive mental health treatment. He does have
do you need a place to
towards
stay?
violence.
I have like some nights
No, you were telling me earlier that you're living on the street.
I am.
Do you have a place to stay? Okay,
They told me.
if you want, we have places for you to go. I have services for you. I have Shatoria here. We can find you a place to stay if you need it, because the street, it's not a good place to live. The streets will ravage you in ways that you never know. You'll do things just to survive. It's not a good place to be. So if you need a place, we can find you a place. But that's still no excuse to violate conditions of bond. We've ordered you not to go back to this house, right? I get that you may have, issues, where to live, where to stay, who to be with, how to get there. But if they don't want you there, then you can't go. And I mean, they've already called the cops.
I spoke to his family, Judge. They were under the impression that the defendant was living with a friend in their house, so I don't know.
And that's my understanding too, and Tristan did tell me that he intended to go and stay with a friend. But that was 2 months ago, Judge. He's not paying any rent or anything. His situation has changed since then.
Look, I'm trying really hard not to put you into custody, but at some point, your actions become your own and it's on you. I'm not going to keep playing this game. I'm not, I expect you, like everybody else, to live to the conditions. When we tell you not to go back, it's mom or grandma.
I spoke to both, Judge. Grandma wants no contact.
If I hear it happens again, get ready. You're not allowed to use. And I'm telling you now, I'm going to test you for someone dropped the ball here. And I'm going to give you the benefit of the doubt, but I'm telling you, you're going to get tested again. And if it tests positive again, there's no excuse. Now, we have resources to help you. If you want help, all you have to do is ask. We've given you a list of places that you can call, that you can go stay. They will take you in. If you need any other resources, we're happy to help you as well. But at some point, there's just no more excuse. Understand? All right.
Good, Judge.
Hey, that's it. I mean, really, just no more tolerance. I mean, I don't know, this is what, 3, 4, how many times is this?
Our second time back since the first time, but I do understand. I agree. Yes, sir. Yes, sir.
All right.
Thank you, Judge.
All right, Sullivan. So I guess let mom and grandma know, hey, we've tightened the leash. There's no more excuses. Any more issues, let us know. And
Yes, Judge. And to be fair, the mother did tell me that she has not seen him. It was the grandmother. And
okay, well, that's good news. All right.
Judge, and
Okay. Come up, Mr. Wyckoff. What time does court start?
8:30.
You got here, it's now 12.
At the UA, they just told me that I wasn't on the list.
And did he check in at the pretrial, guys? Did Mr. Wyckoff, bottom of page 21, check in at pretrial? Yeah, remember, we revoked his bond. I can't. It's okay. Go ahead.
Earlier and insisted, it says that he insisted he needed a drug test today. And then.
He's right. He's right. The problem is that because we're back at an arraignment setting, we have to redo bond conditions. So that's why they didn't see it, that you have to do it.
Yeah.
Because anytime you get rearrested and you go back into custody, we have to redo all the conditions. So that's why. The problem is that I can't do anything with your case today because your lawyer's not here. So why don't we do this? Why don't we roll it to Monday? Okay. Your lawyer's not here and it's already now nearly 1 o'clock.
You can't call him on Zoom? Or I could step out in the hallway and try to call him?
Go for it. Sure. All right, come on up.
You said that he was finna get on his own.
He's here now. He's here now. So, Mr. Wyckoff, it looks like we had you, you were doing well. When we were testing you like crazy, you were doing well. We stopped doing it, and then you started using again. So guess what happens now?
What?
Go back to the way we were,
Hey,
right?
all right.
Doesn't that make sense? Yeah. Back to the way we were. Don't use. I'm not asking much. Don't use PCP. Don't use cocaine. Don't use marijuana. Don't use alcohol. And as long as you can be like that, then you and I will be best friends. Understand? Okay. So we're going to go back to the way we were because things were going well back yonder. We took them off the bond, those the strict conditions, and it goes back. Okay, Joseph?
Yes, Judge. So is that testing what, once a week? How was it?
No, it's twice a
No,
week.
Twice a week.
Monday and Thursdays.
Okay, sir.
So we will give you a 30-day setting today, which will be your setting to come back. But with us, it'll be Monday and Thursday with him.
Yes,
Okay.
Judge. Understood.
So what day you want to do?
January 22nd, 23rd.
How's that?
That's fine, Judge.
Okay.
Thank you, sir.
22nd. All right, Joseph.
Thank you, Judge.
Make us proud. See you Monday.
Watch, we're on the scene. Truths unravel, and what does it mean? In the halls where stories clash, Oouchie court watch quick as a flash.